Negligence forms the bedrock of civil liability when accidental harm occurs under United States law. It is the primary mechanism for seeking recovery for unintended injuries caused by carelessness. To successfully prove a claim of negligence, the plaintiff must establish 4 distinct, mandatory elements: duty, breach, causation, and damages. Think of these as 4 necessary hurdles that must all be cleared sequentially. This video, however, will focus exclusively on thoroughly simplifying the first 2 critical components, duty and breach. Mastering these initial elements is absolutely essential, as they set the entire foundation for your success on the bar examination regarding tort law. We will break down exactly what the law requires regarding the defendant's initial obligation to the plaintiff, and then analyze whether that obligation was factually violated by the defendants. Conduct. Before diving into the specifics of duty, we must understand the procedural framework. To win a negligence case, the plaintiff bears the burden of proving all 4 elements: duty, breach, causation, and damages, by a preponderance of the evidence. This means it is more likely than not that each element is true. Critically, these elements are sequential hurdles. If the plaintiff fails to establish even one element, the entire negligence claim collapses immediately. For instance, if no duty existed, the analysis stops right there. Therefore, the very first legal question we must answer is, did the defendant owe any legal obligation to the plaintiff whatsoever? This brings us directly to element 1, duty. Now that we have established duty as the essential first step, let us define precisely what a legal duty entails. Legal duty is an obligation imposed by law requiring an individual to conform their conduct to a certain standard of care. This standard exists specifically to protect others from an unreasonable risk of harm. Think of it as the law setting a minimum acceptable level of behavior that society demands. The crucial question then becomes, to whom is this duty owed? The general rule, adopted by the vast majority of jurisdictions, is that a duty is owed only to those plaintiffs who are foreseeable. More specifically, the defendant owes a duty to all foreseeable plaintiffs who fall within the foreseeable zone of danger created by the defendant's actions. If you are outside that zone, the defendant generally owes you no duty. This rule effectively establishes the initial scope of potential liability. Crossing this threshold, proving that a duty existed, is mandatory before we can even consider whether that duty was breached. The previous chapter established that duty is generally limited to the foreseeable plaintiff within the foreseeable zone of danger. Now, we must briefly address a historical split regarding how strictly we define that scope. Most jurisdictions follow the majority rule we just discussed, the foreseeable plaintiff rule. This means if you could reasonably foresee that your negligent act might injure someone, you owe them a duty. However, a minority approach, famously associated with Judge Cardozo in the Palsgraf case, required a more direct connection. Cardozo argued that duty is only owed to plaintiffs within the immediate, direct line of foreseeable risk, the zone of danger. For bar examination purposes, remember this: the modern trend, and the view heavily favored on the multi-state bar examination, aligns with the majority. Duty is owed to all persons whose injury was reasonably foreseeable as a result of the defendant's conduct. If you are outside that foreseeable orbit, no duty exists. While the general rule focuses on foreseeability, the law imposes specific, often heightened, duties in certain contexts. The first major area is premises liability, which dictates the duty owed by landowners or occupiers to people entering their property. This duty depends entirely on the visitor's status. First, to a known or anticipated trespasser, the duty is minimal. Avoid willful or wanton injury. Second, to a licensee, such as a social guest, the owner must warn of known, hidden dangers. Finally, the highest duty is owed to an invitee, like a business customer. Here, the owner must inspect the premises for unknown dangers and make them safe. Moving beyond property, we encounter professional duties. When a defendant is a professional, such as a doctor or lawyer, the standard of care is elevated. They do not owe the duty of a reasonable person, but rather the duty commensurate with the standard of care exercised by members of that profession in good standing. This specialized standard is crucial for specialized fields. We just examined duties that arise based on status, like landowner obligations or professional standards. Now, we turn to a distinct and often counterintuitive area: affirmative duties to act. Generally, under common law, there is no duty to rescue or aid a stranger, even if you could do so easily and safely. This is often called the no duty to rescue rule. However, this rule has critical exceptions where the law does impose an affirmative obligation to help. First, an affirmative duty arises if a special relationship exists between the parties. Think of a common carrier and its passenger, or an innkeeper and a guest. Second, a duty is imposed if the defendant's own prior conduct caused the peril or placed the victim in a position of danger. Third, if the defendant voluntarily begins to render aid, they assume a duty to continue that aid reasonably, meaning they cannot leave the victim in a worse position than before they started helping. These exceptions are vital for understanding when inaction itself becomes a breach. We have now thoroughly established who the defendant owes a duty to, including the nuances of affirmative obligations. With the first element, duty, satisfied, we must now transition to the second critical element, breach. Breach is fundamentally a factual inquiry. It asks, did the defendant's actual conduct fall short of the legal benchmark established by the duty? We define breach as the defendant's failure to conform their conduct to the required standard of care. In essence, this is where we compare what the defendant did against what the law required them to do. If the defendant acted reasonably, there is no breach, even if harm occurred. If they failed to meet that required standard, the second element is met, and we move closer to establishing liability. Next, we must define precisely what that required standard of care actually is. We have established that breach occurs when conduct falls below the required standard of care. Now, we must define that standard itself. In the vast majority of negligence cases, the standard imposed upon the defendant is known as the reasonable prudent person standard. This is the cornerstone test for breach. The reasonable prudent person, often abbreviated as RPP, is a hypothetical individual who exercises the degree of care that society demands. Crucially, this is an objective test. We do not ask what the actual defendant thought was careful, or how cautious they subjectively are. Instead, the defendant's conduct is measured against what this idealized, hypothetical person would have done under the exact same or similar circumstances. If the reasonable prudent person would have acted differently, the defendant has breached their duty. This objective measure ensures uniformity and predictability in applying the law, regardless of the defendant's personal shortcomings in judgment or caution. While the reasonable prudent person standard is objective, the law recognizes that not everyone operates from the same baseline. Therefore, the standard is frequently modified. First, the standard is adjusted upward for individuals possessing superior knowledge or skill. A surgeon, for example, is not held to the standard of a layperson, but rather to that of a reasonably prudent surgeon practicing in good standing within that profession. Second, the standard is adjusted downward to account for the defendant's physical characteristics. If the defendant is blind, they are held to the standard of a reasonable person who is also blind under the circumstances. However, mental characteristics, such as low intelligence or forgetfulness, are generally not considered. The standard remains objective for mental capacity. Finally, we address children. Children are generally not held to the adult reasonable prudent person standard. Instead, they are held to the standard of a reasonable child of like age, intelligence, and experience. There is one major exception. When a child engages in an inherently adult activity, such as operating a motor vehicle or heavy machinery, they are then held to the full adult reasonable prudent person standard. We have established the standard of care, whether it is the general reasonable prudent person or a modified version. Now, how does a court actually determine if that standard was violated? This is where the core logic of breach assessment comes into play, often summarized by the underlying principle of the hand formula. A breach occurs when the burden of taking adequate precautions was less than the probability of the resulting harm multiplied by the gravity of that harm. Think of it as a cost-benefit analysis. If it was cheap and easy to prevent a serious accident, but the defendant chose not to, they have breached their duty. If, however, the cost of prevention was extremely high relative to the small risk posed, the court might find no breach occurred. To summarize this first half of our journey, duty establishes the legal obligation owed to the plaintiff, and breach confirms the defendant's failure to meet that required standard of care. With duty and breach satisfied, we move on to the final two hurdles in proving negligence: causation and damages.